Hi, and thanks for joining me. On today's episode, we are going to look at the procedure of how to draft a court order. Now, orders are used when you file a motion. There's something that the judge signs. It's where you set forth the relief that you are looking to have granted, and the judge will go ahead and, if your motion is granted, will sign that order, and that piece of paper, that order, becomes an official court order that all the parties are obligated to follow. We're going to show you today how you draft an order, so stick around. Hi, my name is Peter Lamont. I'm a business attorney and the host of utlradio.com, your business success and legal information station. And right now what we're going to do is hop over to the computer and I'm going to show you a sample order and explain step by step how you would go about creating your own. Now remember, an order is used in conjunction with a motion. It's what the judge signs and then ultimately becomes a legal binding court order that all the parties have to adhere to. Now, it doesn't make a difference what sort of motion you are filing. An order is going to have the same format. Of course, it's going to be different from state to state. There might be some, small nuances or some language that you use. So I absolutely encourage you to check out your state's court procedures and make sure that the document you're submitting complies with your court's, your state's requirements. But this is a general tutorial on how to draft an order. And again, it doesn't matter what kind of motion, because as long as you follow the same format and the same sort of thought process, you'll stand a good chance of having the judge, assuming your motion is granted, sign the order. So let's get to it. Let's hop over to the computer. All right, so here we are at the computer, and what I want to show you is a general setup for drafting an order. Okay, remember, again, I can't emphasize enough to check your state's court rules and make sure that you are in compliance with the rules. I'm going to show you right now a federal court order. It is very similar, if not almost identical, to what most states require when you're drafting an order in or on the state level. But I'm going to show you the federal courts because the federal court system is unique in the sense that even if you're in a different district, and even though a judge might have a certain peculiarity or local court rule, the general forms are all the same. So we're going to take a look at a draft federal court order. So let's walk through this. What you're going to see here is an overview. This is an order that we are proposing to the court in an effort to grant a motion for summary judgment. Now, remember that this is part of your motion. Your motion consists of your notice of motion, your brief, or your certification, your affidavits, your exhibits, all that stuff. This is also part of it because this is what you want the judge to sign. So let's start from the top and then we'll go down. Okay, so typically what I would do here is I'd lay out my file number. So let's say my file number is, all ones, I'd put it there. Now, if you're representing yourself pro se, I'd put my name here. And then you'd go with your mailing address, your telephone number, your email address, and then attorneys for. Now, you're pro se, so what you'd want to do is maybe say pro se, let's say you're the plaintiff here. Okay, so there you have it. You're the pro se plaintiff. This is the way that your motion should be set up, where you've got the name of the court. Over here, you've got the name of the plaintiffs. So if you're the plaintiff here, your name would go here. So we'll just say Peter Lamont. There you go. And we can take that out because there I am. And let's say the name of the defendants are, I don't know, let's say ABC Inc. Okay, there we go. So that's the case. Peter Lamont versus ABC Inc. I've got all my information up there. I've got the court information. Then you put your case number. Every case that you file receives a case number from the court. You'd put that number there. Let's just leave it as that. And then you want to title your order. So what is it? I've seen this a lot of times where somebody will say something like this. They're just going to go with order or order on motion. And it's okay, but what I prefer to do is to be more specific and make sure that the judge, when he sees this order, understands what it is he or she is signing. So I'm going to spell out it's an order granting summary judgment for, and because I'm the plaintiff, I want to make sure that it says plaintiff. Just a pointer on legal writing, especially with motions. A lot of times if you use a form or if you are using an older document, sometimes it's easy to leave something like defendant in when really you're the plaintiff. So make sure you just are checking all the time and proofreading so that you're actually saying the right thing about who you are. All right, so we have an order granting summary judgment. Now, this is generally standard language. This matter having been opened to the court by, that really means who filed the motion. So in this case, we're going to pretend it's me. So having been opened to the court by me, I'm not really an attorney, so I can just take this out and I can say pro se plaintiff. Okay. On motion for summary judgment, which is what I filed, pursuant to the rule, that's the federal court rule for summary judgment, upon notice to all counsel. That means that everyone was noticed of my motion for summary judgment. So when I served my summary judgment motion, everybody received a copy. And to the court, so the court also received it. And the court having considered the papers and argument of counsel, you're not counsel, so maybe you'd say of pro se plaintiff. Okay. What that means is that the judge considered your papers, maybe heard oral argument, maybe didn't have oral argument. 9 times out of 10 on a motion for summary judgment, you're going to have oral argument. That's all this means. Then you go down here. It is on, it's what day. But you don't fill that in. You leave this blank for the judge to fill in. So you're going to submit it just like this. It is on this day, blank day, of blank month, ordered and adjudged. The judge is going to go back here. Most of the time they hand write in the day and the month when they sign the order. So summary judgment is hereby granted in favor of, well, who do you want to have summary judgment? Clearly, it's you. So you can say plaintiff. Okay. So what you're doing here is you're first laying out what relief you're seeking. What do you want the judge to do for you? Well, you want summary judgment granted in your favor. So we're laying that out right here. And you're also going to, let's take this part out. You're also going to want to see if there is any other relief that you're looking for. So some of that language was left over from another order where I would be a defendant, right? We don't need to dismiss a counterclaim or a cross-claim, I should say, not a counterclaim, a cross-claim. Let's pretend for a minute, though, that there is a counterclaim against you. So you have sued a defendant, and the defendant has sued you back, and you're looking for summary judgment. So you might want to include here, point 2, something like defendants, I got all caps here, hold on. Defendants counterclaim is hereby dismissed with prejudice. Maybe that's something that you want to include in the order. Maybe you need to address something else. Let's say it's a motion for partial summary judgment. You want to identify what it is you're looking for here. So you're looking for. So partial summary judgment on the matter of liability is hereby granted in favor of plaintiff. So all you're doing is reiterating what you're asking for in the motion. And you're putting it here so that the judge can sign it. Now, remember I said that it doesn't matter whether this is a motion for summary judgment or a discovery motion. It's the same format. So let's just take one more second, and let's say that this is a motion for discovery. Okay, so it's an order granting plaintiff's motion to compel discovery. Okay, so now down here, obviously, we're going to change that, and we're going to say on a motion to compel discovery. Upon notice, all counsel again is hereby ordered on this day. What do you want ordered? Well, you're the plaintiff, and you want them to comply with discovery. So, defendant must respond. I can fix that. To plaintiffs, let's say notice to produce on or before what date? Okay, you can leave it blank and let the judge put it in there. You could put it in there if you wanted. You know, when do you want your documents? Let's say you want it on or before 1/1/16. You can stick that in there. Let's say that you also need depositions. Defendant will submit to a deposition on or before. You know, so you could use that language, or you could say on and make it a particular date on 1/5/16. Or you could say we'll submit to a deposition no later than. So you see how you can kind of play around with the wording and make a definite date. You can make a definite deadline. That's all you do here. Okay, that's it. That's how you draft an order. Now the judge then signs it. So you leave this line for the judge, put the judge's name here, and the judge will sign it. Now don't be surprised if, let's assume again, you win your motion. Don't be surprised if the judge crosses out things or adds things. So let's say, for example, on this sample discovery order here, defendant must respond to plaintiff's notice to produce on or before 1/1/16. Maybe the judge doesn't like that date. Maybe the judge is going to give him to the 10th, and then maybe the judge is going to handwrite, again, pretend this is handwritten. Judge might handwrite something like, all objections to demands must be made in writing and submitted no later than, and he gives a date. So in other words, don't be surprised if you see some handwriting on the order. It is very common for a judge to add terms, to change terms. Maybe they'll cross something out. Maybe they'll add something. But this is it. This is the basic formula for writing an order. Now, one thing I want to caution you on is making sure you are very clear with what you want. Make sure that you limit your sentences to sort of singular ideas, not this big compound sentence, like defendant must respond to plaintiff's notice to produce by 1/10/16 and submit to depositions and do this and do that. You don't want that. That's too complex. It's just not the right way to do it. What you would rather see is an individual list. Maybe you drop in a semicolon here and then come down for number 2 and say defendant must, and whatever that defendant must do. This does a couple things. It separates your ideas, so if the judge doesn't like one thing, he or she can cross off or amend that one item as opposed to crossing out your whole thing. You want to make this very easy for the judge to read, easy for the judge to understand, easy for the other side that ultimately will be served with this notice. So if you're successful on your motion and you need to then serve the order, you want to make sure it's really, really clear. So be careful with the way that you write your order. Now, we're not going to get into more as far as writing and being careful with what you write, because we're going to do a separate video about legal writing and how it's important that you actually say what you mean and you don't leave any ambiguity out there or any loopholes, but we're going to talk about that in a separate video. For today, I just want to make sure you understand the basic overview, the general overview here of what an order looks like and how you prepare it.